So we're going to segue from our last panel, and really, we have this great opportunity to get a view from the bench. So first of all, I'm going to do some introductions. I'm greatly honored to be moderating this panel and having the opportunity to introduce Judge Thomas and David Searle. And let me just tell you a little bit of background about Judge Thomas. She graduated cum laude at the Indiana University School of Law. But what I can tell you is, oh, sorry. I'm going to be yelling in everyone's ear here. I'll sit back. Judge Thomas has really an illustrious career before she even hit the bench. She must have been every other type of attorney I can think of. When I looked on her bio, it said, she practiced law as a private sector attorney for a number of years. She was an adjunct assistant professor at the University of Indiana. She was a county attorney. She was a trial advocate, et cetera, et cetera. And she also, she was at the EEOC in Indianapolis, where she went from a trial attorney all the way up to a regional attorney. And this is all before hitting the bench. And so in 1990, she actually was at the U.S. Administrative Law Judge at the Office of Hearing and Appeals, Social Securities Administration in Indiana, Evansville, Indiana, from 1990 to 1995, before she actually joined up with her present job, where she's at as a U.S. Administrative Law Judge at the Department of Justice Executive Office for Immigration Review, EOR. It's actually easier to say than that long title. But interesting enough, she must have just had so much energy because also during her time as an administrative law judge, she also served as a temporary member of the Board of Appeals, and that's the U.S. Board of Immigration Appeals, the BIA, part-time. Amazing. And I think she'll talk a little bit about that. Here we have our Grand Assistant U.S. Attorney, David Searle. Although he is from Texas, he should feel at home because he received his bachelor's degree in economics here at Stanford University. And thereafter got his JD at Duke School of Law. And then after spending about 5 years doing civil litigation and appellate law, he moved up to be an assistant U.S. attorney in the Southern District of Texas. Okay, and he was assigned to the Major Offenders Division and Organized Crime Strike Force. Now, if that doesn't bring fear into your heart, well, he also has a variety of other crimes that he was involved in, including worksite enforcement, illegal reentry, alien smuggling, hostage-taking, and document fraud. And he was the local assisting USA on the famous IFCO case. And of interest to any government speakers that are out there, he also taught classes to ICE and the assistant USA's worksite investigation, I guess, at various centers. So he's versed to talk about our criminal section. But first we're going to start off with Judge Thomas and get the view from the bench. And I'm hoping that Judge Thomas would give us some background and share with us some information about OCAHO's past and present.
Thanks. I have a couple of preliminary comments. I have to tell you that until this morning, I would have said I've been doing this work for quite a while. But now, having heard the previous panel, I realize I'm a newbie. I do have to thank our hosts for inviting me. I've never been to Palo Alto before. It's lovely, so I'm glad I got to come. The other thing I always have to say is that any remarks or opinions that I express are strictly my own, not those of the Chief Administrative Hearing Officer, the Director of EOR, the Attorney General, or anyone else at all. And they are, moreover, not intended in any way to suggest of any view I might take with respect to any case that is currently pending or is likely to come before me in the future. That said, let me bring you up to date on OCAHO. We now have a new Chief Administrative Hearing Officer after having had actings for a while. That is Robin Stutman, who is former General Counsel for the Executive Office for Immigration Review, and before that came to EOR from the Office of Special Counsel for Unfair Immigration-Related Employment Practices, from whom you'll hear a little bit later. going to do today is talk a little bit about Oklahoma, not just where we are today, but where we've been, and look at some of the events that were spoken of in the earlier panel, but from a somewhat different perspective. Oklahoma is the office of the Chief Administrative Hearing Officer. And I'll tell you a little capsule of its history. It came into being pretty much about the same time as the first handbook for employers. So what that means is we're coming up on our 25th year. The prior panel mentioned there was, after the initial passage of the Immigration Reform and Control Act of 1986, a period of time when the former Immigration and Naturalization Service engaged in an educational effort to bring the word to employers about what they had to do. And during that period, there was sort of a grace period with no enforcement. So it took a little while to gear up the enforcement. Then, as now, the cases that came to Oklahoma were broadly in two categories. The 274A cases that were spoken about, either knowing hire of undocumented or unauthorized employees, or failure to comply with the requirements of the Employment Eligibility Verification System, that is, the I-9 process. The other side of that were the cases that came to us under the non-discrimination provisions, that is, employers who allegedly discriminate against employees or employment applicants on the basis of their citizenship status, or in certain cases for national origin where that's not otherwise covered by Title VII, and for engaging in acts of retaliation against employees for participation in activity that's protected under the statute. So that's the basic territory that we covered from then until now. The cases come to us in very different ways. Initially, the 274A cases were brought by the Immigration and Naturalization Service after the inspection and a notice of intent to fine. The agency then will file a complaint. The discrimination cases come to us through a different process that goes through the Office of Special Counsel. Those cases require that an individual or organization file a charge with the Special Counsel's office, after which the individual or organization can bring their own complaint, or the complaint can be brought by the government. The principal difference, I would say, from an employer perspective in terms of these two types of cases is that there are strict time limitations on the discrimination cases. Those charges have to be filed with the agency within 180 days of the time the events occur. The agency has a limited period of time to conduct its investigation. There is, again, a limited period of time within which a complaint has to be filed. With respect to these sanctions cases, there basically is no limitation put in the statute itself on the length of time that the government has to file a complaint. So, going back to what Dan said earlier about potential liability, you're looking basically at a statute where you can have a notice of intent to fine, let's say in 2006, and a request for hearing is made, and a couple of years go by, and the agency then is at liberty still to file a complaint. So as far as the statute is concerned, there's no limitation there. So potentially a lot of exposure. Some protection, which we'll get to a little bit later. Currently pending, I checked at the beginning of this month, we now have pending in the office as of the first of the month 86 cases, 52 of which involve the sanctions provisions, 34 of which involve discrimination. That's pretty much in line with the filings that we saw in the last fiscal year. FY11, we saw 88 filings, 61 were sanctions, and 27 were discrimination cases, and that's pretty much the ratio that we've been seeing for the last couple of years. This is a far cry from what we've seen in the period before that. And I have to say, first off, that that's not a huge number of cases when you consider this is a nationwide program. And this is the number of cases that have reached this level. But it's a significant change. Probably the peak period for cases coming before our office was from about 1989, when enforcement first geared up, until 1999 or so, when it kind of petered out for reasons which I'm not really sure of. But those of you who were around then will remember that there was a substantial effort being made for the repeal of the sanctions provisions. And that effort was not limited to business interests. It was joined by labor unions as well, most notably probably the AFL-CIO, which had been one of the sponsors of the legislation in the first place. So that was a growing movement toward the repeal. And I think all of that came to an abrupt end after September 11th, 2001, and we haven't really seen that kind of momentum for a repeal since that time. In the next period after that, I would say from 1999 to almost 2009, we did not see a whole lot of activity. We continue to see a fair number of cases in the discrimination area, although mostly not from the government. There were from professional associations, private individuals, labor unions, farm worker advocacy organizations. But we did not actually see a single sanctions case filed between April of 2002 and October of 2007, not one. And barely a trickle for a while after that, until about the middle of 2009, when, from our perspective, they really shot up. But again, in absolute numbers, this is not a huge number, but from our perspective, it's a pretty big increase.
And you're the only judge that currently hears these cases, so that is a large number if you have 86.
Well, yes. You know, when I came to Oklahoma in 1995, we had 4 judges, and as time went on and the filings went down, some of my colleagues retired and they just weren't replaced because the caseload at that point didn't justify it. And I think since probably 2005 or so, I've been the only one, and for a while that, you know, Marcine mentioned I was moonlighting at the Board of Immigration Appeals, but because I didn't have enough to keep me busy. Well, that's changed quite a lot, and I think that from an objective standpoint, or from my point of view, we're probably going to be needing another judge pretty soon if this rate of filings keeps up. Whether we will get one is another matter. These are days when government is constrained, and I'm not just talking about our department, but across the board, government when budgets are being reduced, not increased. So, you know, at some point, resources, tough decisions have to get made about what kinds of resources are available for what purpose. I want to make a couple of observations about what we're seeing, and that is the businesses that are being charged. And again, I'm probably going to give short shrift to the discrimination cases in this panel because I think the main interest is in penalties, and we'll get to that pretty promptly. We're seeing a lot of cases in construction industry, and I include landscaping in that, as well as in hospitality. And I don't know whether that's because the perception is there are a lot of undocumented workers in those areas. Probably the biggest source of confusion that I see in the cases that come before me stem from quite legitimate grounds. So the employers are confused about the good faith because it appears 3 times in the statute, and in each instance it's in a different context and with a somewhat different effect. Well, the first of these provisions is in the original statute, and that's the so-called safe harbor. Complete defense to an employer against a charge of knowing hire violation if the employer has complied with the employment eligibility verification system and has done the I-9 and done it right. The fact that the documents the employer looked at might turn out to be falsified or fraudulent is not going to come back and bite the employer if the I-9 is done right. So it's important from that perspective to do it right. This makes sense when the employer's only obligation is to verify that the documents reasonably appear to be genuine and reasonably appear to relate to the individual. The employer is not the guarantor of the authenticity of the documents. The second place that the term good faith appears in the statute is a result of the 1996 amendments that Paul Virtue mentioned, the Bono Amendment. Employer is entitled to a defense with respect to technical or procedural violations if, after being given 10 days notice, the employer corrects those violations, has a clean I-9, then there's a pass as to those violations. The third time that the term good faith appears in the statute is in the penalty provision as one of 5 factors that must be considered in setting a penalty. The others being the size of the employer, the seriousness of the violations, whether the individual is unauthorized for employment, and any history of previous violations. The approach of OCAHO to penalty setting has, I say always, but over a long period of time, been that there's no single approved or authorized way of going about setting penalties. Statute prescribes that 5 factors must be considered. It doesn't say anything about not being able to consider additional factors. It doesn't say anything about having to weigh those factors the same way in each case or equally as they're applied in a particular case. Historically, I think our judges have taken one of 2 approaches, what they call the so-called mathematical approach, which quantifies the continuum from the minimum to the maximum penalty and carves that up into portions and assigns value to those portions. Suppose the principal advantage of an approach like that is predictability. The other approach that's been taken is the so-called judgmental approach, which is a somewhat more flexible, but may lack the kind of predictability that adheres to the other approach. Having outlasted my colleagues, most of the cases now are approached with a judgmental approach. Well, that's why I asked her which one, what's the consequence of outlasting your colleagues? There you go. So, do you want to jump in and talk a little bit about the 5 factors, or did you want to finish up a little bit more on? No, I have just one more comment, and then we can come back to the factors. And that is, like most civil litigation nowadays, the majority of these cases are resolved by way of settlement or motion practice. And the case that goes to the full hearing anymore is the exception. It was not so true in the early days, but it's certainly true now.
Okay.
So.
Yeah, so before I want to jump back into the 5 factors, since we had a whole panel talking about substantive versus technical and procedural violations, and I think you touched upon the Bono amendment that Paul Virtuoso told us those very fantastic stories that got us all back in tune with what's going on here with the 10. So Judge Thomas talked about the 10-day rule, which actually allows individuals, the employers, to correct a technical or procedural error within those 10 days. And if they don't, then it becomes a substantive error. And so that's what we're focused on today, is substantive versus technical, and especially what is a substantive error. And some of you might say, well, really, what's so important, and why does it matter whether this is substantive or technical, whether that error that I made on that I-9 is categorized substantive or technical? A big difference, because a substantive error or violation, that is what the government can charge the employer with. 1 count for 1 substantive error on an I-9. So it really doesn't matter if you have 10 substantive errors on that I-9, they can already just charge you for just 1. So your goal is to make your I-9 clean and free of all errors, but especially do not have any substantive errors, because you're not going to be able to make avail of that 10-day provision that will allow you to correct. So that's what we're looking at here. And I guess going back to Judge Thomas, there's some confusion since we don't have regulations, and attorneys and corporate compliance officers, we're confused about which are substantive and technical and procedural, because nationwide we are seeing differences in the charging of substantive and technical or procedural errors. So in determining which errors are substantive or technical procedure, what does our cohort do? What do they rely on? Do we rely on Paul Virtue's memorandum?
That's what there is. And until such time as there is a regulation or some other guidance, that is the guidance, I think, that ICE is intended to rely on, at least when a case comes to us. That is our expectation. And indeed, I mentioned to Marcine, we have a recently published decision out in, coincidentally, Stanford, sign and warning, no relation to Stanford. But basically what happened was a motion for summary decision was taken under advisement pending submission of additional evidence as to whether, in fact, the government actually had given the 10-day notice and the requisite time to make the corrections, and if so, what was wrong with the corrections that the company had made, because that was not evident from the materials that came with the motion. So that is definitely our expectation, that until there's some other guidance out there, that's what they're going to be following. Now, that doesn't address every possible violation, but it covers a lot of them, and it's still authoritative as far as our cases are concerned.
I think one of the areas that has brought up a lot of confusion is in the area of timeliness. You know, thinking, is it substantive or technical? And for those of you who might not understand what the timeless error is, it's when there's a violation that occurs, and the violation occurs, the act that an employer does, let's say they have to fill out Section 2, and they have to do that within 3 business days from the time that they hired the employee. They don't do that within those 3 days, then the time is run, and they have a timeliness violation. So these you can't really go back and correct as you can when we were talking about crossing out, initialing, and correcting. That, well, you know, the time has passed. There's the error, it stands. What do we do with that? And so that's an issue, is that can be considered a substantive or technical error? If it's a substantive error, it never goes away. Right, you're always going to have that error, and you're going to be fined. The government can fine you for a timeless violation. If it's technical, well then you have 10 days to cure that. So Judge Thomas, can you give us some guidance or point to a few cases that might help us deal with timeliness issues that might occur in the workplace?
Yeah, I mean, I'm glad you raised the question of timeliness because, as I mentioned earlier, there's no time limitation on when the government can file a complaint after the employer files the request for hearing. But there are some limitations on that. As you mentioned, there's no cure for timeliness violation, but one thing about it is you know when it occurs, and it's complete when it occurs, unlike most so-called paperwork violations, which are regarded as continuing in nature. So, absent any limitations period in the statute itself, we look to the so-called spillover statutes, 28 U.S.C. 2462, that basically says for in any action to enforce a proceeding for a civil money penalty, unless otherwise provided by statute, the time limit is 5 years from the date that the violation first occurred. There are problems with this in terms of when did the violation accrue, but you know that there's no accrual problem with a timeliness violation. You know exactly when it occurred. So there is a statute of limitations that's going to run against those violations. The other limitations period, I guess, in terms of exposure is with respect to former employees. You can't correct those either. But since the employer has a duty to retain the I-9 only for 3 years after the date of hire or 1 year after the date of termination, whichever is the more recent, there comes a point where the employer can just ditch that I-9 and be done with it. And I suppose that is why my colleagues have emphasized the desirability of purging your I-9s with your former employees as soon as you can get rid of them to do that. So those are some of the things that can provide some protection in terms of timeliness. But most of those violations are continuing.
Thank you. So I think we're running short on time, so I want to move to some of those 5 factors that you talked about earlier. As Judge Thomas told us, the statute provides that when we're looking at civil penalties, that we have to look and give due consideration to those 5 factors. Again, they're the size of the business factor of the employer being charged, whether or not there are unauthorized workers, good faith of the employer, seriousness of the violation, and history of previous violations. And you might think, wow, why is this important? Well, when you have your base penalty of whatever it might be, at least under the 2009 recent ICE penalty memorandum, what they have done is they've taken these 5 factors, they allocated each with a 5% up or down. So that's 5 factors times 5, 25%. So what they have done is probably the government's going to try to aggravate it up as much as they can to 25%. And attorneys, what our job is to try to mitigate that 25%. And so if you have a $100,000 fine, then, you know, hey, that's a quarter of your profits. You can either go up or down. So it makes a lot of sense to really know, you know, how to help your client, if you're an attorney, mitigate or aggravate these business factors. One factor that's confusing is size of a business. Are we just talking about the size, like the number of employees, Judge Thomas?
No, we look actually at a number of things, and I have to say, I mentioned to Marcine, this from an adjudicator's perspective, you can't look at something if the employer doesn't give it to you or the parties don't give it to you. So, you know, you can make findings only on the basis of what information you're given. But in terms of size, the number of employees is only one of the things that we would look at. You look at turnover rate, you look at, if you have the information available, profitability, the length of time in business, the geographical spread, whatever financial data you have. But I want to specifically talk about the number of employees and maybe give an example. It is one thing to have a case, and we had one not too far back, snack attack, you might remember, where the number of employees involved for the period of time that the that I was just looking at was 100, around 100. But in fact, this is a fast food restaurant. They have a lot of turnover. At any given time, they had 12 employees. So, when you look at just the figure of 100 employees, that looks like a lot. But this is sort of a different situation from an employer that has 100 employees all the time, as opposed to some that work for a week and leave and are replaced in a period of time. You add up to 100, but it's still a pretty small operation. When the parties don't give us enough information, I think some of our cases, you'll see that we have consulted such sources as the SBA manual, that is the Small Business Administration manual, classifications of kinds of employers and what's relative size. It's one of the few things we can use that the parties don't have to provide for us. But we're just really dependent on what they give us.
And I think what Judge Thomas is saying is that, really it's the duty of the employer, if they go to OCOHO, to really provide enough evidence so she can make a finding for a small business. If you are in a situation where you have a big turnover in employees, you need to show that to her and make that evident. So it's really the burden is on the employer to pull together the evidence to help their case out. And she's saying that oftentimes, if she doesn't have that evidence, then she can't rule on it. So I want to move into the factor of unauthorized workers, or unauthorized alien factor. So if you get a notice of finding, the government issues one, and it does not charge the employer for unknowingly hiring or continuing to employ an unauthorized worker charge, should we assume that this factor cannot be aggravated? I mean, if you're not finding any unauthorized workers on the worksite? Does that make sense?
Let me say this, that generally speaking, uncharged violations are not going to be factored into consideration. There's at least one case out there that at least took note of in consideration of the fact that there had been a previous warning letter from the former INS against the employer. And it's certainly not irrelevant if there's a large presence of undocumented people in the workforce. But when it comes to imposing a penalty on the basis of unauthorized workers where that has not been charged, what the statute says as that factor is whether the individual was unauthorized for employment. So we're looking at that specific I-9. It doesn't say we're going to penalize all the violations because there are some undocumented workers there. It says whether the individual was unauthorized. So as to that specific I-9, if the government can show that that individual was unauthorized, yes, that's would be.
And the aggravation would only be for that I-9, that individual.
That individual, and I think there's language out there in our case law that we're not going to aggravate a penalty for this person because some other person was unauthorized.
Right.
That's specific to, then that's the statutory language, whether the individual was
So do you think it's your view that if we don't find any unauthorized workers, would OCOHO be inclined to mitigate this factor if there was?
I'm not really able to answer that.
Okay, no, I understand that. And it's maybe 2%, maybe. Okay, good answer. Okay. I'm just we're gonna move on to David in a second, but I just thought we'd talk about the good faith factor a little bit because
that's probably the most disputed one. We seldom see, nobody has a history of previous violations because there haven't been any. But there's seldom any conflict between the parties about seriousness either. The case law is pretty clear. There's a continuum and what the ranges are. But there's a lot of dispute about what is good faith or isn't good faith. Our cases have tended, for better or worse, to focus on what the employer did prior to the inspection. That is, the steps that the employer took beforehand to find out what the law requires and to conform its conduct to that standard. Now, that said, there are other things that might factor into it as well, but that has been the principal focus of our case law in approaching good faith. What did they do before?
Before?
That's right.
Okay, so before the notice of inspection? Before, yeah. So I think that's a key issue here. So for employers, you need to proactively go ahead and complete those I-9s and do what you need to do under the law as far as compliance prior to ICE coming in and issuing that NOI. Otherwise, you on this particular factor, good faith factor, you're going to be in a situation where anything you've done after, even if you complied and did your best to cooperate with ICE, it's not going to count as good faith under this particular factor.
It isn't meant to suggest that you should dig in and fight the investigation.
No, not at all. And just a little bit about discretion before we move on. Review discretion of Oklahoma.
Well, like any discretion, it's there to be used. And use it or lose it.
Use it or lose it, she says. And really, since she's the only judge, and she's really, since she's out with the other judges, she's, I guess actually, she's been using her discretion, and we had a little discussion about, her flexibility as a judge because of discretion, and you can see that in the different ICE memorandums that come in and the way that they charge, that they might be more restrictive to follow what the guidance is out there, but in Oklahoma, the judge is given that freedom under the statute of discretion. So remember that when you file your case with Oklahoma. So moving right along, we are going to jump right into talking about criminal penalties. And David has put together a short presentation for us, and hopefully you can run that through quickly and give us a little bit of background and talk about how you would charge for a criminal case.
Thank you. It's very nice to be here. I'm, as Marcine said, a criminal prosecutor, a federal prosecutor from Houston, Texas. And I'm going to talk to you a little bit about the criminal justice system and how it is that you can avoid, if you're an in-house counsel or a practitioner, your client becoming part of it. I'm going to talk a little bit about how we prioritize cases. Of course, not every Worksite case goes into a U.S. district court, and how it is that we get our cases. And then a little bit about the criminal penalties that we can charge. There's a wide, vast gap, I guess you would say, in prosecutorial discretion, too, in these types of cases. And then go on to talk a little bit about how it is that we prove these cases, because we generally don't like to bring charges that we can't prove. And then, of course, talk about how it is that we decide whether or not, against corporate targets in particular, whether to bring criminal charges or whether to dispose of matters through what we call non-prosecution or deferred prosecution agreements.
All in 20 minutes.
All in 20 minutes. Record time. And so here's a list. I'll go through these real quickly. In our district, the Southern District of Texas, which is the largest district in the United States as far as the number of prosecutions and, in particular, immigration prosecutions. We have priorities in our district. There's 93 federal districts. Each one is free to set its own. Each U.S. attorney is appointed by the president. But these in our district is what we focus on when deciding when to go criminal or what to look at. First on the list, and consistent with the Department of Justice's emphasis on national security and combating terrorism, is cases that impact critical infrastructure. This might involve contractors who are at airports or military bases. Recently, we had a prosecution earlier part of this year that we disposed of through a non-prosecution agreement in our office against a company that built modules for the U.S. military that were sent overseas to Iraq. A lot of these companies that become targets in this first category face serious consequences, not only as far as what the stigma of a potential criminal conviction might be, but debarment from government programs. The second category, which is the most common, are what we call egregious worksite violations, and these focus really on a large percentage or a significant number of undocumented aliens that are working at a particular employer. Whenever ICE brings me a potential case in the early stages, the first question I always want to ask is, how many undocumented workers are we talking about? And why is that important? Because we can only do so many of these cases. We get the best bang for our buck in these cases, and that's why we prosecute them. And we also tend to find that when there's a significant number of undocumented workers at a particular employer, where there's smoke, there's fire. You may see active recruitment of undocumented workers. You may see the transportation or housing of them being paid for by the employers. So we make that a priority. Thirdly, we also make a priority, independent of the number of workers or the percentage of the workforce, cases in which there's the exploitation of the undocumented workers. We do find this occurs in certain industries more than others, but you'll find an accompaniment of OSHA, or Department of Labor, wage and hour violations. These are very important cases to prosecute. In certain industries, certainly there is a market for workers who are willing to work under poor working conditions that otherwise people lawfully present in the United States would not take those types of jobs. So we prioritize those cases. Where do our cases come from? All different sources. As you saw in the last presentation, the number of notices of inspection have greatly increased over the past several years. I think it's interesting that the vast majority of our cases, however, do not come from referrals through notices of inspection. Now that may start changing. ICE is certainly free to refer cases to us when they find there's a significant percentage of undocumented workers at a particular location, working at a particular company. But most of the big cases we've had have come from other sources. The IFCO case that Marcine mentioned, that I was very privileged to be local counsel in Texas. It was a case that originated in Albany, New York. Before it went to trial, I was brought on because the prosecutors from New York became very nervous when they found out we pronounce jury selection voir dire in Texas. Then they found out I was originally from California, and they became even more concerned. But IFCO is really the granddaddy of criminal worksite cases. It began really with a truck driver in Albany, New York, a union driver, calling up ICE in Albany, which only had a handful of agents, because he was upset after a number of workers, pallet workers, came out of a meeting and tore up their W-2 forms right in front of him. And several years later, 16 guilty pleas, 8 felony pleas included in that, a forfeiture of over $20 million, several compliance measures put into place, and a noisy raid, I guess as you would call it, in 2006 that saw 1,180 aliens at 50 different IFCO plants across the United States detained by ICE and then deported. It all wound up in Texas. All that because of the report of a single truck driver up in Albany, New York. In the Southern District of Texas, we've gotten cases through some other interesting sources. Through the media, we had a case against Republic Waste Services a few years ago that resolved actually in 2008. That came to us after local media in Houston reported that Republic, which had trash contracts with the city of Houston, was overbilling. And also during that presentation, local news mentioned there were a number of undocumented workers. Now, this particular Republic subsidiary that was, or office I should say, that was engaged in the hiring of undocumented workers responded to those media reports not by terminating the workers, but by trying to get them status, which of course became admissible potentially as evidence against them. We did resolve that through a non-prosecution agreement, mainly because Republic, being a large national company, the wrongdoing was limited to this one particular office, this one particular subsidiary in Houston. And also, along the lines of that, again, the stigma of a criminal conviction of a large company like that, and I'll talk about this a little bit more in a few minutes, it did not make sense to go forward with an indictment in U.S. District Court. Civil suits, Shipley's Donuts, which is the Krispy Kremes of Texas. We brought a case against them also a few years ago after we got our mitts on a civil deposition transcript, a civil suit that was brought by several undocumented workers at Shipley's Donuts complaining of mistreatment. After we got our hands on that, a federal grand jury subpoena was sent to the company. And I suppose this crosses lines of all different types of criminal cases beyond Worksite. If you're an in-house lawyer or a practitioner not familiar with criminal law, never ever have someone who's not familiar with criminal work respond to a federal grand jury subpoena. In that particular case, we knew from the deposition transcripts that this company had a lot of documents that were not turned over in response to the subpoena. So we went and packed the place up. ICE executed a search warrant, and we discovered that there were 30 aliens, undocumented workers, actually living on company property. It resulted in individual criminal charges against the founder's son, Shipley Jr., and also several managers who were abusing the undocumented workers, in a forfeiture of $3 million, including the property on which the aliens were housed. In informant action rags, that was another hot raid or hot inspection case back in 2008, where over 250 aliens were administratively arrested, and along with several managers who were criminally arrested at a textile plant in southeast Houston.
So a nosy raid, hot raid.
Nosy raid, hot raid.
Got it.
I had never heard that term before, but I'm going to start using it. Nosy raid's probably better than hot raid. And then citizen complaints, Atrium Companies. It's a case I recently investigated. We resolved through a non-prosecution agreement. There was a particular subsidiary in a neighborhood in Houston. Local residents complained about sort of off-hours activities of a lot of the workers who turned out to be undocumented who were at that particular location. Our core statutes, when I talk about there being a lot of prosecutorial discretion in this area, this is what I'm talking about. These break down, and these are the statutes that would be charged or threatened to be charged in probably 90% of criminal cases, all of which are found in Section 1324 of Title 8. The traditional smuggling statutes, it's interesting, which are both felonies, and that would be the concealing, harboring, or shielding from detection of unlawful aliens, or the encouraging and inducing of aliens to enter or reside in the United States. Those are both felony charges, and they carry a maximum possible penalty of either 5 or 10 years, depending on whether the offense is charged as a conspiracy, which we often do in worksite cases, for reasons I'll tell you in a moment, or whether it was for financial gain, which in nearly all worksite cases is the case. There's always some economic story or motive normally for why undocumented workers are being hired in significant numbers. What's really interesting and important, though, about worksite cases when they go criminal is that the mens rea that we have to prove as federal prosecutors, if we bring a charge under one of these traditional smuggling statutes, believe it or not, is only reckless disregard, which is interesting because the comprehensive statutory framework created by 1324 literally in IRCA requires actual knowledge. Now, courts have pretty much settled on the fact that we have discretion, even though the words employment are not mentioned in either the traditional concealing, harboring, or shielding from detection or encourage inducement statutes. We have the discretion to bring those in the employment context in worksite cases, and we have in egregious cases. What type of conduct fits into those terms, which are, I would say, liberally construed generally by courts? Concealing, harboring, or shielding from detection would certainly include transporting or housing undocumented workers. It would include assisting workers with procuring false documents. It would include tipping off workers about an impending immigration raid, those sorts of things. As far as encourage inducement, there's very little case law on this. I think you can make a logical argument from the plain meaning of those words that simply giving someone a job might be encouraging or inducing them to remain in the United States. But it is an open issue, and it has not been decided by a court whether a mere employment case, that is a case without the aggravating type factors I just described for you, could be charged either under one of those. I would note that the harboring statute, at least, it's interesting, prior to IRCA actually excluded specifically, and Paul can correct me if I'm wrong about this, mere employment, but those words were actually removed, which gives arguments to people like me that we could charge a mere employment case. Now, as a practical matter, we don't do that. We look for those additional factors I've mentioned.
Oddly enough, it was called the Texas Proviso.
It was. All the things come from Texas, yes, yes. Also, under the traditional smuggling statute, there is a provision there, and you'll see it's the third one down,
Right.
that criminalizes the actual employment, and it uses the word employment, of 10 or more unauthorized aliens within a 12-month period. It's a 5-year felony. We are required to prove actual knowledge in that case. I've actually never charged that. I'm actually not aware of anyone ever charging that, at least in our district, not just because actual knowledge is a bigger hurdle potentially, although there are certainly arguments in a lot of cases for what we call a willful blindness or deliberate indifference instruction as to the alienage, and we can request that and get that in certain circumstances. But the main reason is it's actually harder sometimes in a federal criminal case to prove a particular alien was unauthorized. We generally charge these cases of as conspiracy because we don't necessarily have to bring the aliens in themselves. And with Sixth Amendment confrontation rights, those sorts of things, it's not enough for us to just prove up on the papers that someone might have been undocumented. If we charge a substantive offense for the employment of aliens, we need to have those aliens there as material witnesses, or we need to be able to argue that the I-213, the record of admissible alien, is admissible on its face to prove alienage. But by no means is that a given. In the IFCO case, for example, as we were preparing for trial, the judge in that case made it known that he was on the fence and likely to exclude the I-213s as evidence, which means we would have had to have called in all 1,180 witnesses as aliens as witnesses, and I wouldn't be here today because the trial would probably be still going on, although most of them are back in their home countries. And then, of course, IRCA, the comprehensive statute passed in 1986, provides a misdemeanor, up to 6 months of imprisonment, a fine for 3,000 alien for the actual hiring or continued employment of unlawful aliens, unauthorized persons. Now, we have to prove a pattern or practice. What does that mean? I'm not aware of any case law that says it. Probably means more than one, I guess, unless you kept firing and rehiring the same person over and over again. That generally hasn't come up too much. But again, I think the lesson here is we have some very serious statutes at our disposal, and we do use them in cases where we believe that they're warranted. These are other ways that employers can be charged. I won't spend a lot of time on this. The first two are aiding and abetting an employee's commission of document fraud. That's the counterfeiting or possession or use of counterfeit or false documents, or the alien's claim on a Form I-9 of being a U.S. citizen. That also ties in with false written statements, either under Section 1001 or the visa fraud statute, which is 1546b3, which actually specifically criminalizes making a false attestation on a Form I-9. Money laundering, everyone's always very interested in whether we charge money laundering in criminal cases. We generally don't. Money laundering, certainly just the depositing of dirty funds, that would be the proceeds from the employment of undocumented workers is not enough for money laundering. Something funny needs to be done with the money, I guess, is the best way to summarize money laundering. You certainly need what's known as a specified unlawful activity, and the immigration statutes I mentioned all qualify as that. But we need to see more, either concealment of the source of the funds that is being sent into a shell company, something like that, or that the funds are reinvested into the enterprise. Maybe if you had a company transporting aliens or housing them, and the profits were being recycled back to further that, we might consider charging money laundering. We do use money laundering sometimes in non-prosecution agreements where we need to use civil forfeiture as a basis for forfeiture because we don't have a criminal conviction. Non-prosecution agreement is a letter agreement between the U.S. attorney and the particular corporate target. And so in order to make things legally sound, we will rely on civil forfeiture. Under the civil forfeiture statute, the immigration statutes I mentioned, believe it or not, are not vehicles for forfeiture, but money laundering is. So we would then find a factual basis where we could show money laundering occurred either under the theory I just told you or under Section 1957, which is known as the spending statute, which is where unlawful obtained proceeds are spent in excess of $10,000. Proving employer knowledge. A lot of this is pretty straightforward. As a prosecutor, the best evidence you can have are witnesses, either cooperators, material witnesses themselves, undocumented workers who can say, against individuals, Manager X certainly knew I was unlawful. I told him. I told him I bought my documents for $300 from the flea market, and he said, well, that's great. Here, just sign or don't sign this I-9. We do use undercover recordings, or ICE does, and those are admissible in court. Those can be very effective in cases. They were very effective in getting the early felony pleas in the IFCO case. A lot of the managers there were caught on recordings in Albany and in Boston. Form I-9s themselves, I think it's fair to say that, problems with the I-9s themselves, I wouldn't be very excited, as it was said in the last panel, employers, we realize as a practical matter, are not document experts, and I certainly would not want to ask 12 lay people sitting as a jury to convict someone beyond a reasonable doubt, just finding that they should have been a document expert but weren't. But the I-9s, or the lack of presence of the I-9s, maybe most particularly in criminal cases, still can be evidence of showing sloppiness or disregard for hiring. Payroll records, these can be used to show systematic underpayment of workers, either failing to meet minimum wage requirements, or what it seems more common, at least in some larger companies, is the failure to pay proper overtime. Maniac's letters, we could talk for an hour about those. I hope most of you are familiar with those. They were no longer sent, at least what are known as EDCOR letters, which were these letters that would send out up to 500 Social Security numbers that did not match employees' names for a particular company. Social Security Administration stopped sending those in 2006. The last year they were sent was for tax year 2005. And whether those are admissible or not in a criminal trial is unsettled. The letters did say on them specifically you shouldn't infer that a particular person whose number is listed here is undocumented, but nevertheless, a flagrant disregard for those certainly could be shown as evidence that an employer was turning a blind eye toward what was going on. And of course, the ratio of documented and undocumented workers, the higher the number of aliens, IFCO being the prime example of 1,180 aliens, a jury is going to infer that there was probably some knowledge on the employer's part. Okay, when do we decide that a corporation, as opposed to an individual, may become a target? Well, certainly it has a lot to do with what happens on the front end. How egregious is the conduct? What is the percentage of workers or the number of workers who are illegal? The second bullet point up there I think is very important. Remember I mentioned the federal grand jury subpoena, which now not having the lazy rate is an instrument we've been using a lot more to put a company on notice that they are a target. If a company responds to that by obstructing justice or failing to take remedial measures when they're on notice that a significant percentage of their workforce may be unauthorized, wholesale responds. Of course, we expect employers to respond consistent with the anti-discrimination provisions in 1324a. But if they simply do nothing because they're putting profits over principle, that certainly makes them a target in our eyes. Obviously, the exploitation, housing the aliens, transporting the aliens, those bottom three are from the Republican Shipley's cases that I already talked about.
I think this is all that we're looking at, corporate charging principles.
Yeah, I can cover those just real briefly. I mean,
Talk about, go ahead and, cover that briefly, and maybe then we'll have some questions.
Sure. Before we can charge a corporation, any business entity in the Department of Justice, we have to analyze under our U.S. Attorney's Manual's 9 factors. And those can be broken down in the U.S. Attorney's Manual. What's noted up there, the Ashcroft memo generally requires us to charge the most seriously readily provable offense. When we're talking about business organizations, however, there are other considerations. And those include the stigma of a criminal conviction. Those would be adverse effects to stakeholders, including employees, the local community, stockholders, debarment possibilities. So we look at a lot more things than just the conduct. The 3 C's, I guess, is the best way to describe them. How much has the business organization cooperated with the government since they've been put on notice of this violation? And this is probably the most important in this day and age, and luckily I know we're having a panel here shortly on compliance. What type of compliance measures were put in place, not only beforehand, but once the company is on notice, that we may be looking at them for a criminal prosecution. And as I mentioned, the collateral consequences. And if you're curious, all 9 factors are actually listed here, and you'll see that a lot of those break down into conduct. But I would say that compliance and timely remediation, if a company has both of those going, there is a very good chance that they will not be criminally charged as an entity by the U.S. Attorney's Office. Particularly managers might be who are culpable, but a business organization can go a long way by having a robust compliance program in place and by timely remediating the workforce once they're put on notice.
Great, thanks.
Marcine, I have a question for you. Are you willing to make those PowerPoints available afterwards?
Yeah, absolutely.
Great. We will be posting the PowerPoint, all the PowerPoints that speakers make available on the website afterwards, with details saying where to go and how to get it. So that's the first thing. The second thing is 1 or 2 questions, as long as the panel particularly promises to make yourself available during perhaps the afternoon break, which is a half-hour break, so that people
Absolutely.
won't cut short. But maybe take 1 question, 2 questions, go for 2 more minutes. Is that okay, Marcine?
That's perfect. You're reading my mind. Wendy?
I have a question for Judge Thomas. I wanted to ask your opinion on whether employers should continue to correct I-9s in the eve of the receipt of the NOI. We've heard some guidance and we've heard from some ICE officers that once you receive that notice of inspection, you should stop correcting. Because any corrections you do after, especially before you present it to us within those 3 days, are not going to be given any consideration. Do you have a different opinion?
I don't have an opinion at all. I really don't know.
Do you think that employers should continue to correct because the violations could be continuing in nature, and you could have, in some cases, the violation might have stopped, due to the statute of limitations?
No, seriously, I don't know.
We'll footnote that question.
Yeah, we're gonna footnote and ask that question on some of the other panels. It's interesting, and see what Judge Thomas will think about that.
Last question.
Okay, last question.
For David, in the IFCO case, is there any truth to the fact, or the potential fact, that one of the reasons that there was a thought that there were so many illegal workers was because there were so many Hispanics who didn't speak English?
Well, I'm not sure I understand your question.
In other words, profiling of Hispanic workers.
By the company?
No, by the U.S. Attorney's Office in the Northern District.
No, I don't think that's true. I think the fact that there were 1,100 undocumented workers there probably speaks for itself. If you wanted to talk about the evidence as far as why there were a lot of undocumented workers there, there's some things that were public I could talk to you about, but no, if you were going to pick out even a case where there might be potential profiling, I don't think IFCO would be the case to mention.
Great. Well, thank you. That concludes our panel, and we will be preparing for the next